I'm Jason Witten. Today I'm in one of my favorite cities on earth, Taipei, Taiwan. I'm here to talk to you today about Federal Acquisition Regulations and Defense Federal Acquisition Regulations Supplement, known in short as FAR and DFARS. When you enter into a contract for a government contract, the government has these regulations that it has to follow, and they have certain numbers. And they look like laws, but they're actually not laws. So what I want to talk to you today is about what these things are and when you have to agree with them and when you don't. Because in fact, especially if you are the subcontractor to a private contractor, many of these clauses are optional. Perhaps the primary contractor has to abide by them, but that doesn't mean that you do. And in fact, when you see them is in contracts, there'll either be a paragraph, usually towards the back of the main contract, or there'll be a separate attachment to it. And in it, they'll just list out these numbers that look like statutes. Well, these FARs and DFARS, they're not actually statutes. They are regulations that if you're the government, you have to insert sometimes, but sometimes you don't have to insert. They're optional. In essence, they're just proposed contract provisions. Some are mandatory. Those are known as mandatory flow-down provisions, like FAR 52.222-26, which says that you can't discriminate against people in the workplace. But a lot of them are not mandatory, and that's what we should talk about today. So now, as we were discussing, some of the FARs and DFARS are mandatory flow-down provisions, but actually most of them are not mandatory. Let me give you an example. FAR 52.223-18 is a recommendation that your employees not text while driving. That's not mandatory. You know, even if they're not mandatory, a lot of the ones that are mandatory can be confusing to apply and have lots of exceptions. For example, you've got the Buy American Act at 52.225 of the FAR, and the DFARS equivalent is at 252.225-7001. The problem with the Buy American Act is that there are so many exceptions to it. Like, is your product a commercial off-the-shelf product known as COTS? Or is your country part of the World Trade Organization, WTO, like Taiwan is? And then there's a whole other problem about even if your product is made in the United States, what percentage of it actually came from a foreign country? You have to calculate that foreign percentage. So the Buy American Act is a perfect example of how confusing these can be about what is mandatory and what is not. But again, you have to identify what part of each part of the FAR or the DFARS is optional, and then negotiate away those clauses that you don't want to have apply to you. Okay, so now that you have a basic idea of what the issues are with the mandatory flow-down provisions and the voluntary ones, let's focus now on some IP clauses that are in the FAR and the DFAR. In the Federal Acquisition Regulations, you'll find IP clauses at Part 27. It's called Patents and Copyrights. Some are required by law. For example, if you have a patent infringement case against the government, pursuant to 28 U.S.C. 1498, you can only get monetary damages. You can't get an injunction. Or, of course, if what you're working on is classified information, you can't divulge that either under 18 U.S.C. 792. But the rest are basically optional. And you'll find a whole section in Part 52.227 that are just contract clause after contract clause that are just proposed wording. Now, if you're contracting directly with the government may make you take those. But if it's not a mandatory flow-down provision, there's no law that requires you to accept that as a subcontractor to, say, like a Boeing or a Lockheed. Now, the DFARS mirror of the Federal Acquisition Regulation for IP is found at Part 227 of the DFARS, and the proposed contract terms that come off of Part 227 are at Part 252.227. Some examples of these are 252.227-7013, which are rights and technical data, which doesn't include software, but that can be found one clause after it. 252.227-7014, rights in non-commercial software. And basically what those do is they are provisions requiring you to turn over data to the government for products that you sell them. But the issue becomes this, is are you really selling them a non-commercial product? A lot of times, subcontractors will be selling just an off-the-shelf product to, say, like a Boeing. And Boeing's then going to incorporate that into a non-commercial product, probably a weapon system or something like that, or an airplane, to the government. So while Boeing will have a non-commercial product, you will not have a commercial product. And there's a whole other section of the DFARS that handles rights in commercial data, and that's at 252.227-7015. The most important thing to take away from those three sections, though, is that whether you're dealing with non-commercial versus commercial, is you can restrict it. Now, the government's going to need more data if it's a non-commercial product, because arguably it's more sensitive. But if you look at section 252.227-7017, that will tell you how you can restrict how the data is used that you turn over. Finally, a couple more IP-related DFARS are these. At 252.227-7026 and 7028, the government would like you to continue to give them data for another 2 years after the end of the contract. That's optional. Another one is 252.246-7001, where the government will want a 3-year warranty beyond perhaps what you've already offered. Maybe your warranty is only 2 years. Again, though, that's optional. If you're dealing directly with the government, yeah, maybe you have to take these things. But if you are dealing with, for example, a subcontractor situation where you are the subcontractor to a prime contractor, these are optional. Again, don't believe just because they are part of the Federal Acquisition Regulations or the Defense Federal Acquisition Regulations supplement, or even the more specialized DFARS that are for each branch of the military, that you actually have to accept these. In conclusion, don't be fooled by FARS and DFARS. They're not laws. Some of them, of course, are mandatory, but most of them are voluntary contract clauses. You know, of course, bargaining power is going to matter the most, just as it is in any kind of contract negotiation. But remember that, especially if you're a subcontractor, your customer who's contracting with the government has to get the best deal possible for the government. And also, if it's on a fixed price contract with the government, it's going to want to get the best price from you to max out its own profits. Under those kind of circumstances, you may find that your customer is willing to concede all of the non-mandatory voluntary provisions because they want to get the deal from you. You offer the best product for the best price. Be skeptical about the FARS and the DFARS that you're asked to accept. Don't take them at face value. You may not have to accept all of them. I hope that gives you a little bit better insight into what FARS and DFARS are. If nothing else, maybe it's made you think of a few more questions that you have. Well, I wish you all the best. Thank you.